Welcome to our comprehensive guide on compromises, arrangements, and amalgamations under corporate law. In today's business world, mergers and acquisition are not just buzzwords, they're essential strategies for growth, survival, and transformation. However, the legal frameworks that govern these processes can be complex and sometimes mystifying. In this video, we'll break down the key concepts, explain the powers of various stakeholders, and walk you through the procedures and protections embedded. Clarify two fundamental terms: compromise and arrangement. A compromise refers to a peaceful settlement of a dispute, where each party makes concessions to reach a mutual agreement. It assumes there is a disagreement to resolve. In contrast, an arrangement doesn't require a dispute. It's about modifying rights among members or creditors, often to reorganize a company's capital or structure. Arrangements can include actions like converting debt to equity, reducing share capital. Amalgamation is a legal process where two or more companies blend into a single entity. The company that merges into another is called the transfer company, while the one that absorbs is the transferee company. Amalgamation can take the form of a merger, where businesses combine to continue as one, or a reconstruction, which typically involves reorganizing a single company's structure. These schemes are often part of broader compromises or arrangements, allowing companies to pool resources. There are two main types of amalgamation: those in the nature of merger and those in the nature of purchase. In a merger, there is a genuine pooling of assets and liability, and the business of the transfer company continues under the transferee. In a purchase, only assets and liability are taken over, and the original business may not continue. The choice between these types affects accounting methods and the rights of shareholders, making it crucial for companies to carefully consider their restructuring strategy. Amalgamation to be classified as a merger, several conditions must be met. All assets and liability of the transfer company must become those of the transferee. At least 90% of the transferor equity shareholders must become shareholders in the transferee company. The consideration is paid entirely in shares, except for fractional entitlement. The business of the transferor is intended to continue, and no adjustments are made to book value except for accounting policy. If any of the merger conditions are not met, the amalgamation is considered a purchase. Here, the transferee company may not continue the transferor's business, and the consideration can include cash or other assets. This type of amalgamation is more flexible but may have different implications for accounting and shareholder rights. Understanding the distinction helps stakeholders anticipate the effects on their interest and the company's future direction. Chapter XV of the Companies Act 2013 covers sections 230 to 240 and forms the backbone of the law on compromises, arrangement, and amalgamation. It provides a complete code for all forms of restructuring, detailing the procedures, disclosures, and approvals required. The National Company Law Tribunal (NCLT) plays a central role in overseeing and sanctioning these schemes, ensuring that the interests of all stakeholders are protected and that. One of the key features of Chapter XV is its emphasis on transparency. Companies must make detailed disclosure during restructuring, allowing stakeholders to make informed decisions. Voting by postal ballot ensures wider participation, and notices must be served to various statutory authorities. These measures are designed to prevent abuse, promote fairness, and involve regulators in the decision-making process, ultimately safeguarding the interests of members, creditors, and the public. Law also introduces important prohibitions and safeguards. For example, companies are prohibited from maintaining treasury stock through intermediaries, ensuring that shareholding structures remain transparent. Exit options for shareholders, especially in mergers involving listed and unlisted companies, are provided through predetermined formula or valuation. These provisions help maintain a balance between promoters and minority shareholders, fostering trust in the restructuring process. Chapter XV also introduces fast-track amalgamation for small companies and holding subsidiary mergers, streamlining the process for entities that meet certain criteria. Additionally, it enables cross-border amalgamation between Indian and foreign companies, subject to regulatory approval. These innovations reflect the evolving needs of the corporate world, making restructuring more accessible and efficient for a wider range of companies. Section 230 of the Companies Act 2013 lays out the basic procedures for compromises or arrangements with creditors and members. It empowers the tribunal to call meetings upon application by the company, creditors, members, or liquidator. The process involves detailed disclosure, notices to all affected parties, and opportunities for objection. The tribunal's role is to ensure that the scheme is fair, transparent, and in the best interests of all stakeholders. Compromise or arrangement can be proposed between a company and its creditors or members. The application to the tribunal can be made by the company, a creditor, a member, or a liquidator in case of voluntary liquidation. The tribunal may then order meetings of creditors or members to consider the proposed scheme. This inclusive approach ensures that all relevant parties have a say in the restructuring process. Applicant must disclose all material facts to the tribunal, including the company's latest financial position, auditor's reports, ongoing investigation, and details of any capital reduction. If the scheme involves corporate debt restructuring, additional safeguards and valuation reports are required. These disclosures are vital for transparency and help the tribunal and stakeholders assess the scheme's impact. Once the tribunal orders a meeting, notices must be sent to all creditors, members, and debenture holders at their registered addresses. Sectoral regulators and authorities likely to be affected must also be notified. The notice includes details of the scheme, valuation reports, and its effects on stakeholders. For listed companies, documents are also sent to SEBI and stock exchanges and published in newspapers to ensure maximum reach. Stakeholders can vote on the proposed scheme in person, by proxy, or by postal ballot within 1 month of receiving the notice. Objections can only be raised by those holding at least 10% of the shareholding or par petition of the outstanding debt. This threshold prevents frivolous objection and ensures that only significant concerns are addressed by the tribunal. Notices and documents must also be sent to sectoral regulators like the central government, RBI, SEBI, registrar, and others. These authorities have 30 days to make representation. If they do not respond within this period, it is presumed they have no objection. This process ensures that regulatory perspectives are considered in the approval of the scheme. The scheme is approved by a majority representing 3/4 in value of creditors or members and sanctioned by the tribunal. It becomes binding on all parties, including dissenters, and in case of winding up, the liquidator. This ensures that once a scheme is agreed upon and sanctioned, it has full legal effect and can be implemented without further dispute. Tribunal's order may address several matters, such as conversion of preference shares, protection of creditor classes, variation of shareholder rights, abatement of certain proceedings, and exit offers for dissenting shareholders. Importantly, no scheme is sanctioned unless the company auditor certifies that the accounting treatment complies with prescribed standards. This comprehensive approach ensures that all relevant issues are addressed in the final order. Tribunal's order must be filed with the registrar within 30 days. In certain cases, if nubbe petition of creditors by value agree to the scheme, the tribunal may dispense with calling a meeting. This provision streamlines the process when there is overwhelming support, reducing unnecessary delays and administrative burden. Law prohibits the tribunal from sanctioning any compromise or arrangement involving buyback of security unless it complies with Section R. Additionally, takeover offers can be included in scheme, but for listed companies, SEBI regulations must be followed. These safeguards ensure that such transactions are conducted transparently and in accordance with broader regulatory framework. The Section 231, the tribunal has the authority to supervise the implementation of any sanctioned compromise or arrangement. It can issue directions or modify the scheme as necessary for proper implementation. If the scheme cannot be implemented and the company is unable to pay its debts, the tribunal may order winding up. This oversight ensures that schemes are not only approved but also effectively carried out. Section 232 empowers the tribunal to order merger or amalgamation. Applications can be made for reconstruction, merger, or transfer of undertaking. The process involves circulating draft scheme, valuation reports, and accounting statements to all stakeholders. The tribunal ensures that all procedural requirements are met before sanctioning the scheme, protecting the interest of all parties involved. Merging companies must circulate the draft terms of the scheme, confirmation of filing with the registrar, directors' reports explaining the scheme's effects, expert valuation reports, and supplementary accounting statements if needed. This ensures that all stakeholders have access to comprehensive information before making decisions, promoting transparency and informed consent. After verifying compliance, the tribunal may sanction the scheme and make provisions for transfer of assets, allotment of shares, continuation of legal proceedings, dissolution of transfer company, and protection for dissenting shareholders. The order also addresses issues like employee transfer, treatment of non-resident shareholders, and set-off of fees. No scheme is sanctioned without auditor certification of accounting compliance. Once the tribunal's order is made, property and liability are transferred to the transferee company, and any charges may be extinguished. Companies must file a certified copy of the order with the registrar within 30 days. The scheme's effective date must be clearly specified. An annual compliance statement must be filed until the scheme is fully implemented. Failure to comply with filing requirements can result in significant penalties for the company and its officers. The law imposes fines for delays and continued non-compliance, emphasizing the importance of adhering to statutory timelines and procedures throughout the restructuring process. Mergers can occur by absorption, where existing companies transfer assets to another existing company, or by forming a new company to absorb multiple entities. The law also covers division, where a company's assets are split among two or more companies. Understanding these structures helps companies choose the most suitable path for their strategic goal. Courts have clarified that schemes of amalgamation aimed at business consolidation are valid, even if they have tax implications. For example, in the Panasonic India case, objections regarding the transfer of accumulated losses were dismissed, as tax treatment is governed by separate provision. The focus remains on compliance with the Companies Act and the genuine intent of the scheme. A wholly owned subsidiary merges into its holding company, no new shares are allotted, and there is no dilution of shareholding. If the net worth of the transferee company is positive and all statutory requirements are met, the tribunal may even dispense with shareholder meeting. This streamlines the process for group company seeking internal restructuring. Section 235 provides a mechanism for acquiring shares from dissenting shareholders when a scheme or contract is approved by at least 90% in value of shareholders. The transferee company must notify dissenters and can acquire their shares unless they successfully object before the tribunal. This ensures that minority dissent does not block the will of the overwhelming majority, while still providing a legal avenue for objection. Process involves a 4-month offer period, after which the transferee company expresses its intent to acquire remaining shares within 2 months. Dissenting shareholders have 1 month to apply to the tribunal if they object. If no application is made or objections are dismissed, the transferee company acquires the shares, and payment is made through the transferor company, which holds the funds in trust for the entitled shareholder. Section 236 addresses the purchase of minority shareholding. When an acquirer or group holds 90% or more of a company's equity, they must notify the company and offer to buy out the remaining shareholders at a price determined by a registered value. Minority shareholders can also initiate the sale, ensuring fairness and providing an exit route for those who do not wish to remain in a company dominated by a single group. Majority shareholders must deposit the purchase amount in a separate bank account managed by the company as a transfer agent. Payment must be dispersed to minority shareholders within days. If shares are not physically delivered, they are deemed cancelled and new shares are issued to the majority. This process ensures that minority shareholders receive fair value and that the transfer is completed efficiently. After acquiring minority shares, the majority shareholders negotiate a higher price for their shares. They must share the additional compensation with the former minority shareholders on a pro rata basis. This provision prevents unfair enrichment and ensures that all shareholders benefit equally from any subsequent premium received by the majority. Price for purchasing minority shares must be determined by a registered value as prescribed by Rule 27. This requirement was reinforced by case law, where failure to use a registered value rendered the acquisition invalid. The use of independent valuation protects minority interests and upholds the integrity of the process. Section 237 empowers the central government to order the amalgamation of companies in the public interest. Such orders specify the constitution, rights, and obligations of the new entity. Members and creditors must retain equivalent rights or be compensated if their interests are diminished. This extraordinary power is reserved for situations where amalgamation serves a broader societal or economic purpose. Any member or creditor is dissatisfied with the compensation assessed in a public interest amalgamation, they can appeal to the tribunal. No order is finalized until all appeals are resolved and affected companies have had the opportunity to respond. Copies of such orders are laid before Parliament, ensuring transparency and accountability in the exercise of this significant governmental power. Section 238 requires that every offer or circular involving the transfer of shares under a scheme must be registered with the registrar. The circular must include all prescribed information and a statement on the availability of necessary funds. Issuing an unregistered circular attracts penalty, emphasizing the importance of regulatory compliance in share transfer scheme. Section 239 stipulates that the books and papers of an amalgamated company cannot be disposed of without the central government's permission. The government may appoint an examiner to check for evidence of any offense related to the company's formation, management, or amalgamation. This safeguard helps prevent the destruction of evidence and ensures accountability. Section 240 clarifies that the liability of officers for offences committed before a merger, amalgamation, or acquisition continues even after the restructuring. This retrospective effect ensures that responsible individuals cannot escape accountability simply because the company's structure has changed. Section 230 introduces a simplified, fast-track process for mergers between small companies or between a holding company and its wholly owned subsidiary. The process involves notice to regulators, approval by 90% of members and creditors, and filing of solvency declaration. If there are no objections, the central government registers the scheme, bypassing the need for tribunal approval unless objections arise. Registration of a fast-track merger scheme results in the transfer of property and liabilities, continuation of legal proceedings, and dissolution of the transfer company without winding up. The transferee company cannot hold its own shares post-merger, and all such shares are cancelled. This efficient process is designed to facilitate quick and effective restructuring for eligible companies. Section 234 allows Indian companies to merge with foreign company, subject to approval by the Reserve Bank of India and compliance with Section 230 to 232. The law specifies that only mergers and amalgamations are permitted, not demerger or other arrangement. Consideration can be paid in cash, depository receipts, or a combination. This provision opens new avenues for international business expansion. Recent case law has clarified that while cross-border mergers and amalgamations are permitted, arrangements or demergers between Indian and foreign company are not allowed under Section 234. The law is explicit in its scope, and companies must ensure that their restructuring plans comply strictly with the permitted forms and procedures. Summary: the Companies Act 2013 provides a comprehensive and robust framework for compromises, arrangements, mergers, and amalgamation. The law balances the interests of company, shareholders, creditors, and regulators, ensuring transparency, fairness, and accountability. Whether it's a domestic merger, a fast-track scheme, or a cross-border amalgamation, understanding the procedures and protection is essential for all stakeholders. By following the prescribed steps,